The far-right Christian nationalist majority on the Supreme Court has already shown its willingness to reinterpret civil rights statutes to fit a narrower vision of equality, one that erases historical context and ignores ongoing disparities. In Louisiana versus Callais, that philosophy may reach its full expression. The question is no longer whether the court's right wing wants to weaken the Voting Rights Act. It is whether this term will be the one when they finally finish the job. As oral arguments unfold in this hearing, the Supreme Court's MAGA conservative justices appear ready to take another step toward dismantling what remains of the Voting Rights Act. The case centers on whether Louisiana's new congressional map, which created a second majority black district, violates the Constitution. Beneath the technical arguments over redistricting lies a deeper struggle over the future of federal protections for minority voters, and the culmination of a decades-long conservative effort to weaken them. At issue is Section 2 of the Voting Rights Act, the provision that bars election maps or practices that dilute minority voting power. Lawyers for Louisiana, a group of white voters, and the Trump regime contend that the 2024 map itself is unconstitutional because it deliberately accounted for race. If the court agrees, it could sharply limit or even nullify Section 2, making it far harder for minority voters to challenge discriminatory maps and marking another major blow to the landmark civil rights law. During oral arguments, the conservative bloc made its skepticism clear. Justice Brett Kavanaugh framed race-conscious remedies as temporary exceptions that must eventually expire. Race-based remedies are permissible for a period of time, he said, but they should not be indefinite and they should have an end point. His phrasing echoed the majority's reasoning in the 2023 decision, striking down affirmative action in college admissions, and it signalled that same logic could soon apply to voting rights enforcement. The court is now revisiting the boundaries of Section 2 after years of erosion. In 2013, the decision in Shelby County versus Holder gutted Section 5, which had required jurisdictions with histories of racial discrimination to seek federal approval before changing voting laws. That ruling hollowed out the Act's preclearance system and left Section 2 as the only meaningful safeguard for minority voters. The Louisiana versus Callais case could now determine whether even that last protection survives. The legal challenge began after Louisiana drew its congressional map following the 2020 census. The map contained just one black majority district out of 6, despite black voters comprising roughly a third of the state's electorate. Black voters sued under Section 2, and 2 lower courts agreed that the map diluted their political power. The state was ordered to produce a new map, which it did, adding a second majority black district that stretches from Shreveport to Baton Rouge. That compromise map is now under attack. The plaintiffs argue that intentionally creating a second majority-minority district violates the Constitution's Equal Protection Clause and the 15th Amendment, which bans racial discrimination in voting. The Supreme Court's decision to rehear arguments this fall, after previously hearing the case in March but withholding a ruling, suggests that at least some justices are interested in reconsidering the constitutionality of race-conscious redistricting altogether. Janai Nelson, president of the NAACP Legal Defense Fund, opened arguments by warning that the challengers were asking for far more than a new map. If the map at the centre of the case is deemed unsatisfactory, she said, the proper recourse is to remand and adopt one of the many alternative maps that address the Section 2 violation. Instead, she noted the challengers are using the case to question whether Section 2 itself is constitutional anywhere in the country. That argument tracks closely with a conservative legal theory that gained traction over the past decade, that federal oversight of state election laws represents unconstitutional racial engineering. It's a theory with deep roots in the modern conservative movement and within the court itself. Chief Justice John Roberts, who authored the Shelby County opinion, has criticized the Voting Rights Act since his early days as a young lawyer in the Reagan Justice Department. The hostility towards strong voting rights enforcement, a long fringe view, now defines the court's majority. Legal experts note that Louisiana v. Callais could produce several outcomes. The justices could affirm Section 2's constitutionality, maintaining the current standard for racial vote dilution claims. They could go further and declare Section 2 unconstitutional, effectively ending the Voting Rights Act's practical force. Or they could craft a narrower ruling that preserves the statute in name, but makes it nearly impossible to use by tightening the standards for proving racial discrimination or banning any explicit consideration of race when drawing maps. The latter outcome may be the most likely and the most damaging in the long run. By keeping Section 2 formally intact but limiting how it can be applied, the court could claim to respect precedent while stripping the law of real power. Such a decision would mirror the court's pattern in other voting and civil rights cases, in which it has nominally upheld statutes but interpreted them so narrowly that they lose effect. Behind the legal language is a political reality. The conservative justices, many aligned with the far-right nationalist legal movement that coalesced under the Trump presidency, have long sought to roll back federal protections that constrain state control over elections. The notion that every voter should have equal access to the ballot and the federal government can intervene to ensure it has never sat comfortably with the American right. The Callais case offers an opportunity to fulfill a vision that dates back decades, returning election power to the states and curbing Washington's authority to enforce racial equality at the polls. Whatever the final ruling, its implications will extend far beyond Louisiana. Weakening or eliminating Section 2 would make it vastly harder to challenge gerrymandered maps, voting restrictions, or electoral systems that dilute minority representation. It would also mark the most consequential rollback of voting rights since the 1960s, and is part of the larger project that makes America white again. I'm Anthony Davis. You can find me on the 5 Minute News YouTube channel and podcast, on Wednesdays co-hosting Uncovered, and on Sunday on The Weekend Show with Midas Touch.